Okay, good evening, everyone. So I think if I'm not wrong, then I'm live also. Are we live? Can somebody please confirm that whether we are live or not on YouTube? Can somebody please? Okay, how's everyone by the way? Please, somebody please confirm me that whether we are live on YouTube or not. Yes, we are live. Okay, so let me start this session with a warm good evening to everyone. So I keep this. This is my honor to bring Sweta ma'am here live with us uh, because today's session she will be engaging, and I'm pretty sure that today's session is gonna be very interesting because I have full faith in her teaching because of two three reasons, and I'm not going to explain those reasons for no reason that why will I explain. Because I just want you all to check it that whether whatever I'm saying right now is totally correct or not, that what kind of faculty she is. And I'm very much sure that dedication I saw her preparing the presentation. And with that note, I would like to call Shweta ma'am here. Ma'am, if you're here, then
Yes,
please.
sir. Good evening, sir.
Okay, good evening.
Thank you so much for inviting me to deliver today's session. I am truly honored and excited to share my insights. Thank you and good evening to all. So, I hope I am audible. I'm audible to everyone.
Guys, we want you to please uh, say something so that it can
Yes.
be a very
Okay.
interesting interacting session.
Okay. Okay. So, today's session is about, I think most of the students dislike this subject, jurisprudence, but it is indeed, it's very interesting. So, I will share few things about jurisprudence because it's a detailed subject. It's not possible to cover only with few minutes or like in today's session only. So firstly we will discuss that what jurisprudence is. Jurisprudence, it has been derived from two Latin term, that is juris and prudentia, which means knowledge of law or skill of law. Now, the thing that the prudentia, which means knowledge basically it is of various kinds. That is, it can be theological knowledge, it can be philosophical knowledge, or it can be applied knowledge. Now, with in the context of jurisprudence, theological knowledge means it basically theology is something where we study or where we gain knowledge about the God. So it is here theological knowledge in the context of jurisprudence. It means we will get the knowledge regarding the God made laws or the divine laws. Similarly, philosophical knowledge, it is something about the knowledge regarding the existence and the reality of some things, the existence of things, the reality of things. So here we will get to know about those things only, the law relating to like the applied laws, those with the laws which are existing in a given society. And similarly, the applied knowledge, it means like it is about law, as we know that law is a means to social transformation. So there are laws, the laws are being emancipated from the application, like there for example, juvenile justice act, POXO act. So there are prior to 2012 there was no specific legislation regarding POXO, but it was the need of the hour. We felt that now we need a specific legislation regarding POXO. And in the year 2012, like from the application of that, from our knowledge, application of our knowledge, we can feel that it is the need of the hour to legislate to enact a particular legislature regarding that particular subject matter. So knowledge, it can be of theological knowledge, philosophical knowledge, as well as applied knowledge, based on which we make the laws. Similarly, the knowledge of law, this law can be of various kinds, various types. It can be public law, private law, as well as the substantive law, procedural law. It can be of domestic law or municipal law, as well as international law. So, knowledge of law basically covers a wider area where we will discuss all these things. So, the law, it is here in the the law of course is a term of various connotations, but here we use the term law in its abstract sense only. Now, what is the meaning of abstract sense? Abstract sense, it means that in the sense of concrete statutes, but in the sense of, not in the sense of the concrete statutes, but in the sense of principles underlying. Now, what does it mean? It means that there are various, that there are various branches of law prevalent in any like modern state. Say, for example, there are, torts are there, contracts are there, law relating to property, crime, labor relations. There is like, it's a broader area. But in jurisprudence, while you will study jurisprudence, we have to study only the basic principles of each of these branches, not in detail. Means here we are not concerned with the detailed rules of these laws. Only we will study the basic principles of each of these branches. Say, for example, like if you study penal, for example, you are studying criminal law. So here, jurisprudence examines only the general principles of penal liability, but it does not attempt to detail about the essentials of each crime. There are so many crimes, offenses relating to body, offenses relating to reputation, property. But in jurisprudence, we will not study all these things in detail. Here, we will only examine the general principles of the penal liability, nothing more. So, we can say that jurisprudence, it may be considered to be the study, to be a systematic study of the general principles of law. Like here, we are only concerned about the term law and justice. We will get a crystal clear picture about what the law is and what the justice is. Like, that there are right, liabilities, all these things are their punishment, all these things you have already studied in various branches of law. But what is right, what is liability, what is property, what is ownership? If your rights are getting violated, how you will get the remedy? All these things, all these general principles, we will get to know from the jurisprudence. I think it is clear what the jurisprudence is. What do you mean by jurisprudence? Is it clear to everyone? Jurisprudence is not only about the like what this particular law is. It is only concerning the general principles. It is the systematic arrangements of the general scientific study of the general principles of law. Now, there are various schools of jurisprudence. From these schools, you will get to know that what law was in the primitive era, what law is in a given society, how the societal development we will like there are various phases through which there are we the law is being developed. So there are from these various schools of jurisprudence you will get to know, there are detailed analysis about the development of law in prevailing societies. So basically, there are 5 schools of thought, schools of jurisprudence, that is analytical positivism, historical school, then it is sociological schools of jurisprudence, then natural schools of jurisprudence, and lastly, realistic schools of jurisprudence. So, in today's session, I will specially discuss that focused on the analytical schools of jurisprudence, mainly emphasizing Austinian point of view, Austin's concept of law. So, how many of know that what the Austin's theory is? Anyone can? What is Austin's theory or analytical jurisprudence? Anyone have any idea regarding analytical jurisprudence? Anybody? Prateek, Sanoj, anyone else? Analytical jurisprudence. What it is? Okay. The major premise of this particular school, it deals with the law as it exists in the present form. As it is, law as it is applicable in a given society. The exponents of the analytical school of jurisprudence, they considered that the most important aspect of law is its relation with the state. They treat law as a command which is emanating from the sovereign authority, from the ruler. It is this particular school is also known as because it is based on the command. So this is also known as the imperative school. Their concern is not only about what the law was in past, what it was, but they nor the future aspect of law. But they confine themselves only to the study of law as it actually exists in a given society, nor with the past, what law was, nor with the future of it, neither the past nor the future. But they confine themselves only to the study of law as it is applicably in a given society, or you can say as it actually exists. So basically, there are various jurists of law. Bentham, the jurist of this particular school, Jeremy Bentham, John Austin, Hans Kelsen. So, in today's class, we will discuss basically the Austinian concept of law. John Austin, his theory mainly based, his theory is famous for command. It is mainly emphasized on the aspect of command, the command of the sovereign. He is considered to be the father of English jurisprudence. He confined his study only to the positive law, and for this purpose, he applies the analytical method. Now, what is the meaning of law as per Austin? So, he describes laws. Austin meant that laws properly so called and improperly so called. Now, what is laws properly so called? Can anybody tell what is laws properly so called? क्या होता है लॉ प्रॉपरली सो कॉल्ड क्या है और लॉज इम्प्रॉपरली सो कॉल्ड क्या होता है? हियर वी आर स्टडीइंग पॉजिटिव लॉ. प्रॉपरली सो कॉल्ड का क्या मतलब होता है?
Maybe statutes.
Maybe statutes. Okay.
Yes,
Anyone else? See, he defined law as a rule which is laid for the guidance of an intelligent being by an intelligent being having power over them. So positive law, according to him, is the aggregate of rules set by a man who is politically superior. He is the sovereign, he is the ruler. To govern whom? To govern those who are politically inferior. Means the subject here are those who are politically inferior. And the superior, the sovereign, the ruler is the one who is politically superior. So from this particular point of view, according to him, positive law basically it has four essential characteristics. Number one, that is the command, then it is a sanction, then it is a duty, and lastly, it is a sovereignty. Means one ruler will be there, he will give a command, and those who are politically inferior, means the subjects, they are bound to obey his command. They are duty bound. So, third is the duty. And if you are not fulfilling the duty, if you are disregard his command, then sanction is there. So these four are the essential characteristics of positive law according to Austin. Now, by positive law, he meant laws properly so called. The properly so called are those laws where sanction is there. जहां पे आप अगर कुछ वायलेट करते हो लॉ, आप अगर उनका कमांड नहीं फॉलो करते हो, then you will get the sanction, you will be punished. On the other hand, he says that morality, the moral laws, they are, according to Austin, he described the moral laws as laws improperly so called. Which means why these are improperly, the moral laws are improperly so called? Because they lack force, they lack sanction of the state. So, positive law, Austin distinguishes this positive law from positive morality as because it lacks the force or the sanction of the state. He identifies law with command, duty, and sanction. Now, according to him, existence of law is one thing. Its merit and demerits is another. What does it mean? Say for example, अभी slavery practice होता है हम लोग की society में. Slavery? Whether?
No, ma'am.
No? Okay. So according to Austin, existence of law is one thing, its merit and demerit is another. By this particular term, he tries to say that a law which actually exists is a law. Now, it is immaterial whether the subject, those who are politically inferior, whether it is good for them or bad for them. As it is the command of the sovereign, so it is the law. And people, those who are politically inferior, they're bound to obey that particular law. Now, if the ruler says that you have to practice, like slavery is in existence, then you have to practice that irrespective of the fact that it is bad for the, like it violates the rights of those who are the subject, irrespective of the fact, as because it is the command of the superior, so they are bound to obey this. If not, then sanction will be there. Am I clear up to this? What is positive law according to Austin? Is it clear?
Yes, ma'am.
Only four essential characteristics are there according to him: command, sanction, duty, and sovereign. There will be a ruler. He will give the command or the order. Those who are subject, the politically inferior persons, they are duty bound to obey it. If not, then sanction is there. According to him, this positive law is the only subject matter of jurisprudence. There is, like, There is no other subject. Only the study and analysis of positive law is the subject matter of jurisprudence according to Austin. He divides law into two parts. One is laws set by God for men, and another one is human law. This particular one, laws set by God for men, this is according to him. Laws improperly so. On the other hand, the human laws, these because it is being enacted, it is being framed by the sovereign. Clear? So this is the imperative theory or command theory of Austin. Now, so law, there in every law there will be a command. People are duty bound to obey that command. If not, sanction is there. This theory, there are various criticism why this theory is not applicable. If you see the like in today's democratic setup, this theory is not wholly acceptable. Various criticisms are there. Do you think that sovereign is the only source of law? How many of you agree with this? That sovereign is the only source of law. Sovereign is only the source of law. How many of you agree with this term? Anyone else? Sovereign is only the source of law.
No, ma'am.
What the other sources of law? Custom. Whether
Judicial
custom
precedents,
can be a source
legislation.
of law. Precedent, custom. These are also the source of law, na?
Yes, ma'am.
In Austinian concept of law, you can see that customs completely overlooked. Austin's view that law is the command of the sovereign, it is not supported by the historical evolution of law. The historical evolution of law, here, custom played a very significant role in regulating the human conduct, isn't it? Customs still continue to be a potent source of law, even after coming into the existence of the state. The family laws, family law 1, family law 2, which is uncodified, but the family law 1, you have studied, I guess. So there you can say that source of law. Here, custom plays a very vital role. Similarly, in Austinian concept, there is no place for judgment law. What is judgment law? Can anyone explain what is judgment law? Have you heard the term judicial activism? Judicial activism, judgment law.
Guys, we request you to please reply.
Ma'am, I have not heard about judicial activism, but a judicial precedent, like when the judges give their judgments, and the judgments are referred to as judicial precedent, which help the future cases similar to those.
Yes, similar to those. Judgment law basically is a body of law which is derived from the judicial decisions rather than the constitution, or rather than it is derived from any statutes. Here, judges, they are actively participated in the law making process, judicial decision. The law that is derived or that is based on the judicial decision rather than constitution or any other statutes. So, in Austinian concept, judgment law has no place. But we can see that in today's democratic setup, judiciary actively participating in lawmaking. There are various decisions, isn't it? Judges follow precedent. Similarly, command, you can say that in Austinian concept, command overemphasized. हर जगह क्या बोलते रहे वो? Command, command, command. Do you think that sanction alone is the means to obey the law? Austin's view that is sanction alone which induces a person to obey the law. Is it correct? Obviously, no. There are many considerations such as fear, such as sympathy, such as reason, such as you can say deference, which may, because of which a person obeys the law. The power of the state is only the last force to secure obedience of law, but this is not the this cannot be the alone means to induce obedience, which, according to Austin, is the only thing why people obey the law. Command as well, command overemphasized. He totally ignored that, like, he was not willing to treat international law as a law in a strict sense. According to him, international law based on positive morality. These rules are mere positive morality. As because when you will study international law, you can see that there is no sovereign authority, there is no sanction. Because of this, according to him, these are mere positive morality. They are not law in a strict sense. So these are few criticism of Austin's command theory. Now, this theory has been given by Austin in the 18th century. But till date, this theory, even in our country, has some significant role. Can you explain that how this theory is applicable in today's context, particularly Indian perspective? Is it applicable in our country? Austinian concept of law, is it applicable in our country? Whether we follow the command theory of Austin, whether it is applicable? Yes or no? How many of you agree with this, that Austinian concept, Austinian command theory is applicable in our country? In India, this is applicable. How many of you agree with this? No. Okay. It is not applicable.
Ma'am, I will not fully disagree, but like the judges give their orders, right? And that,
Hmm.
like, if the Supreme Court judge gives an order regarding a case, his final order that is basically the topmost court of law. So that is the final command or judge's decision. So in a way, the Austin's law is applicable to some extent, I think.
To some extent, it is applicable.
Yes, ma'am.
Mostly not, but to some extent, it is applicable. Okay. So basically, according to him, he overemphasized with the term sanction and the sovereign and sanction. Whatever the, like, it's the command theory. Whatever the sanction will say, that become the law, and people are bound to obey that. But In our country, the sovereign, like in the democratic principle, we follow this democratic system where power ultimately resides with the people, isn't it? Who elect their representatives? People elect their representatives. So the power ultimately resides with the people. As, like, you know that it is the democratic principle, it is a people elected government. So India operates under a democratic system where the ultimate power is in the hand of the people who elect their representatives. And this particular concept, it is in contrast with the Austinian concept of law. Austinian concept or Austin's theory, it mainly focuses on a sovereign's absolute authority. Whatever he will say, that the whether the law is good for the people or bad for the people, this is not the concern. If he will say that you have to follow slavery, then you have to follow, because it is the command of the sovereign. This is the Austinian concept of law, na? Overemphasized on command. So the sovereign has the absolute authority. But in the democratic, in a country where we follow the democratic system, where the power ultimately resides with its people, there it is, their Austinian concept, we cannot say that it is completely followed. In Austin's, according to him, he focuses on a sovereign's, on the sovereign's absolute authority. On the other hand, here in our country, we know that constitution is the supreme law of the land. All the authorities, including the head of the country, that is the president, he also bound to obey the constitution. President is also bound by the constitution now. But according to him, according to Austinian's view of law, where here only the sovereign is the source of all law, and the sovereign himself is not bound by any other authority. So here also you can see that it is not applicable as a whole. Austin's theory only emphasize the positive aspects of law or the formal aspects of law. But Indian legal system, we also considers moral principles, the ethical principles. I think you have studied fundamental duties, which is completely based on our moral and ethical principles, as well as we also follow the concept of justice, which Austin completely ignores, which Austin completely denied. But here in our country, here in our legal setup, you can see that we also we also considers morality and moral and ethical principles, and we have incorporated this in our legal system. So while the Austinian's concept or Austin's theory of command theory, it basically provides a framework for understanding law as a system of commands, the direct and its direct application in our country. Not only in our country, Austinian concept of law is not direct applicable to any democratic system, where the ultimate authority in every democratic system, you know that ultimately the power resides with the people. So it is not, this particular theory has no direct application in any democratic setup, and where the constitution principles are the country's legal system based with the constitutional provisions, principles, and it follows the democratic setup. It is based with the the base is the democratic structure. There it is not, it doesn't have any direct application. Am I clear? You have
Yes, ma'am.
studied, how many of you studied A.K. Gopalan's case? How many of you have studied A.K. Gopalan's case? Nobody. How many of you have studied A.K. Gopalan's case? No one? Okay, me too. Here, the petitioner, he was detained under the Preventive Detention Law, Preventive Detention Act, and he challenged the constitutional validity of that particular act, that is the Preventive Detention Act. His contention was that the act had infringed Article 19 and Article 21 of the Indian Constitution. Supreme Court ruled that the act is valid. Why? Here in this particular case, Supreme Court gave the restrictive view that the act is valid, as because it was established by the, it was followed the principle of procedure established by law. But according to petitioner, he challenged that it is validative of Article 19 and Article 21. The law does not mean only a body of rules, but also the law should be fair now. The application of law should not only the body of rules, but it also fair. Therefore, what the legislature has noted must be regarded as the law of the land, even though it did not necessarily render justice according to the judgment of the Supreme Court. What the legislature has noted, even though it did not necessarily render justice, but it becomes the law. So here you can say that in the case of A.K. Gopalan in 1950, this judgment reflects the Austinian concept of law. Later on, it was changed. The viewpoint was changed from the Maneka Gandhi onwards. But here, in this judgment, Supreme Court gave the restrictive interpretation of the procedure established by law, which reflects the Austinian point of view. Am I clear?
Yes, ma'am.
Okay. Anyone have any question? You're free to ask any question. What is jurisprudence and the Austinian point of view of law? If anybody has any question, you are free to ask.
Ma'am, we have a online question that is, can you please explain? This question has been asked by Sweetie Candy. That, ma'am, can you explain John Austin command events once more? John Austin command
Sweetie,
once more. Yes, yes, yes.
pronouncing command. Okay. So, command, basically, what is command? It is an expression of a wish by one person that another should do, or forbear from specified act. So here, like giving an order, that is the command. The idea of command, it must necessarily indicate the existence of sanction behind it, isn't it? A command to be a law must be general, and in no way it can be particular. Austin, he actually, according to him, law is an expression of a wish of whom? Now, of the ruler, of the sovereign, that the subjects shall do or forbear from doing acts. Like either I am permitting you to do a particular act or I am restricting you that you cannot do this. In no circumstances, in no way, you are permitted to doing this. If you are violating my order, then sanction is there. So basically, the idea of command, it indicates the existence of sanction behind it. So the Austinian concept of commands, basically it asserted that according to him that like it is general obedience. This obedience maybe it can be like fear, habit, anything can be there. But you need to obey this at any cost. If not, then sanction is there. You have to bear the consequences. Is it you?
I hope the answer which has been given by ma'am is clear to the person, to the concerned person who has asked. For rest of the people, I really request you all to please open up, guys. Uh, because when I was having a talk with Shweta ma'am, she only told that, sir, I'm gonna deal only one school. If I'll get a good response from the students, then only I'll cover the rest of the schools. So, guys, we have rest more 4 schools to go. So I request everyone to please open up
But
and please.
actually,
But what was the
in
contribution of Jeremy
sir,
Bentham?
Okay. Yes. We have a
Jeremy
good.
Bentham. Okay.
Yes.
So, just like Jeremy Bentham, he was the originator of this particular school, analytical positivism. But the John Austin, he was considered to be the father of this particular school. So, according to the contribution of Bentham, to know this, you should know that what was the view of Bentham's on law. According to Bentham, like his concept of law is imperative one. He defines law as assemblage of signs, declaration of volition conceived or adopted by sovereign or the state. So basically, according to him, if you like interpret this definition, then according to him, he believed that in every law there must be 8 different aspects. First one is the source, that is will of the sovereign, then the subject, the concerned person. It may be a person, it may be things, anything. Then it is the object, like act. I'm permitting you to do certain acts. I'm forbearing you to do certain acts. Or it can be any situation. The third one is the object. Then it's application, like it's extent. You have studied now that contract, it is applicable to whole India. 2019, it is like except Jammu and Kashmir or something like that. Like extent, which like where law covers a particular portion of land on which that particular law will applicable. Then it is the aspect. It may be directive or sanctional. That is the aspect one. The sixth one is the force. In every law, according to Bentham, force is there. And the last seventh one is the remedial, like if your rights are getting, if your rights are violated, then obviously you seek the remedy. So that one, the seventh one is the remedy, remedial state appendages. This one is the seventh one. And the last one is the expression. Like if you're getting the punishment, if you're like compensation is there. So whatever you are like, you need to pay compensation, fine is there, then punishment is there. Everything, these are the expression of the sovereign. Yes, Neha, do you have any question? She has raised her hand.
Yes.
So typically, he believed, according to Bentham, these are the 8 different aspects which should be there in every law. This is the concept of, this is the view of Jeremy Bentham on law. His theory, known as utilitarianism. So Bentham, he actually as an individualist. He believed that the function of law, it is from like the from the he supported the basically the concept of economic principle of laissez-faire, which means that the minimum interference of the state in the economic activities of the individual. So, from this, as because he was supporter of this particular concept, according to him, the function of law should be free the individual from the bondage or from restraint upon his freedom. To give the freedom, this is basically the function. This should be the function of law according to Bentham. And for this, he propounded the principle of utilitarianism. According to him, the right aim of legislation is carrying out the principle of utility. Now, what is the meaning of utility? What is utility? Utility, it is the, you can say that utility is a tendency of a thing to prevent some evil or procure some good. And his theory, his principle, this principle of utility, according to Bentham, he actually tried to say that the proper end of every law is the promotion of greatest happiness of the greatest number. This is actually Bentham's utilitarian. Like, you need to, the correct aim of law is procurance of good by preventing the evil. कैसे होगा ये? कैसे goods, कैसे balance करोगे इसको? Pain and pleasure. How you will balance this? If you are the legislator, if you are the state, तो कैसे इसको, like, how you will balance this? Balance between pleasure and pain. Utility कैसे act करेगा? Anybody? Neetu?
Yes, ma'am. To maximize the pleasure and to reduce the pain. Can principles of this.
Hmm?
This was the view of Dean Roscoe Pound, a noted jurist, and he said to maximize the human pleasure and minimize the pain.
Ma'am just asked how will you
It is a
balance? So obviously
yes.
maximize
What will be the
happiness.
task
So
of the government?
yeah, exactly.
What will be the task of the government? To maximizing the pleasure and minimizing the pain, what should be the task of the government?
The government should administer policies and public policies which are focused towards the welfare of the people, welfare of the public, so that they can benefit.
According to him, to ensure the maximum happiness, the government need to attain four major goals. That is subsistence, abundance, equality, and the security of citizens. The function of law must be to meet these ends, like to provide subsistence, to produce abundance, to favor equality, and to maintain security. These four ends, through these four ends, the government, or like you can say that the task of the government, that is ensuring the happiness, can be done. So like suppose आज अगर किसी के घर में चोरी होता है, अगर हम लोग एक सोसाइटी में है, तो फर्स्ट ए के घर में हुआ, देन सी, ऐसा कंटिन्यूएशन में अगर होते रहा, तो क्या होगा? सोसाइटी क्या होगा सोसाइटी में? ऑब्वियसली एविल एविल स्पिरिट्स आर देयर ना. तो पेन में तो नहीं रहेगा सोसाइटी, प्लेजर में तो नहीं रहेगा, पेन ही है ना. तो पेन, नाउ इफ यू आर द स्टेट, इफ यू आर द गवर्नमेंट, तुमको क्या करना है? हाउ यू विल प्रिवेंट दिस? प्लेजर देना है ना. ये तो प्लेजर नहीं है, सोसाइटी तो प्लेजर में नहीं है. सबके घर में, आज इसके घर में चोरी हो रहा है, कल उसके घर में हो रहा है, परसों उसके घर में हो रहा है. तो दिस इज लाइक, आपको क्या करना होगा? to stop this evil spirit, what you need to do to prevent this evil act or to procure some good, you need to do something. That is, you need to inflict the punishment those who are causing this, like those who are the reason for this evil act. You need to prevent this evil act. You need to punish him or you need to punish them. Then only you can spread the pleasure, isn't it? That is the main task of every law. Like the proper end of every law is the promotion of greatest number of happiness to the greatest, like greatest happiness of the greatest number. This is the main, like this is the end of every law, the proper end of every law according to Bentham. Am I clear, Pratik and all?
Yes, ma'am. Clear.
Okay.
Okay, if anyone is having any
Any
extra,
other question?
yes, please. Any questions? Please raise your questions. Okay, then I am in this presumption that no more doubts is there. We can move further, further in the sense that let me satisfy ma'am that whether she is satisfied with today's session or not, because there was only one condition. I'm gonna tell
Yes,
this to
definitely.
that if she is satisfied, then only she will be conducting next sessions on
No,
the.
I'm satisfied. I just want to ask my students that whether they're able to understand or not.
Yes,
Whatever
this.
I am delivering, whether it is clear to them or not, then only I can, like, I will be satisfied.
Yes,
If
guys.
it is clear to them, then only from my end, I can say, yes, I'm satisfied.
Sanoj has raised his hand. Yeah, you want to say something, Sanoj? Yes, please.
मैम got the most of it, but it would really help अगर आप थोड़ा हिंदी भी डाल दे बीच में तो.
अच्छा, हाँ, एज यू नो कि मेरा हिंदी बहुत अच्छा है, तो थोड़ा बहुत ओके, फ्रॉम द नेक्स्ट क्लास आई विल ट्राई. बट ज्यूरिस्प्रूडेंस एक ऐसा सब्जेक्ट है, इसको अगर हम आई विल ट्राई.
Yes,
As
guys,
most
and
of you
yes,
know, my Hindi is very good. So, okay, next class, I will try. Definitely, I will try.
okay. So we will try to end this session now. With this note, I really want to thank Shweta ma'am and want to deliver this vote of thanks
Thank you, sir.
on behalf of
Thank you, everyone,
all the
for your
students.
patience listening.
Yes, thank you, ma'am. And on the behalf of Sadala Publication, also, I really thank Sweta ma'am and rest everybody who are sitting here joining us for today's session. Next session will be coming very soon, and you will be updated with that session regarding that session also on our website and also on in the WhatsApp group or channel wherever you have received the link. So that only you will be updated. With that note, I really want to say thanks to each and everyone who joined us, and thank you very much.